Welcome to Policing TV and another edition of Talking Crime with me, Danny Shaw. And I'm very pleased to say that my guest today is Professor Fraser Sampson. Now, he may not be a household name, but he has a hugely important job. In fact, he has two jobs. He is the Biometrics Commissioner and also the Surveillance Camera Commissioner. And what that means, in essence, is that his job is to oversee the police use of the DNA database and the fingerprint database, and also the way that police use CCTV cameras and surveillance cameras. That's essentially what he does, and he's going to tell us more about it, hopefully in the course of the next 30 minutes or so. Fraser, thank you very much for joining Policing TV.
Danny, thank you. My pleasure.
First of all, a lot of people won't know this, but you were in fact a police officer for a number of years, weren't you?
Yes, no, I was half smiling there when you said he's not a household name. I think in this setting, I'm fairly glad of that. One of the things I did while I was in the police was I wrote the Blackstone's police manuals, which anyone who's entered for promotion above PC will have had to endure in order to qualify for the ranks of PC to sergeant, sergeant to inspector. And that is a lot of officers. So it's quite difficult sometimes when I visit places to shake off the fact that I am known as the author of the Blackstone's manuals, although I did hand over responsibility for writing those to a team several years ago.
And you served in two forces, is that right?
I joined West Yorkshire Police straight from school. I then spent a long time in British Transport Police, served in a number of settings, was on secondment to the Home Office twice, first as a legal researcher and latterly as the head of examinations, assessment and training, which was based in Harrogate. And that's where I became associated with the Osprey examinations and in particular part 1 and the manuals.
So how do you go from that to your present role? I think you've worked in an academic post. You've also worked, I think, for police and crime commissioners as well. So how does that work?
One of the things that I wanted to do to see if I could do it actually was to qualify as a lawyer. And so while I was at Harrogate, I attended the College of Law in York at weekends for sort of 25 hours of lectures. In order to do what they call the academic stage. It was then for training as a solicitor. So your first entrance was having a law degree, and thereafter you have to do the academic stage, which was a 2-year part-time attendance course. And after that, you then have to do the vocational stage, which is where you have to join a law firm. So literally on the Friday, I was a superintendent in charge of the examinations and assessment team. And on the Monday, I was an intern in the national law firm of Russell, Jones and Walker, making coffee and photocopying and running errands, and also trying to learn the art and tradecraft of being a solicitor. So perhaps unsurprisingly, I did a lot of police cases while I was in that role. And I then moved on to set up a police law department at another national law firm, Walker Morris, where I dealt with a number of high-level police cases, including deaths in custody. I represented the Humberside detectives in the Bishard inquiry. I did the first police disability discrimination case when the legislation was extended to include police officers. And I did other cases around mediation of employment disputes.
You've had quite a career, quite a varied career, and now you've got these two new roles that have sort of become one, because there was a separate biometrics commissioner and a separate surveillance camera commissioner, but the government's decided that one person can do those two roles. Simply and fairly briefly, what does it actually involve? It's a full-time post, is it?
It is full-time post. I mean, each of my predecessors did a 3-day week. So even my lawyer's maths tell me that I've got more than a full week on taking up the role. The biometrics commissioner role is largely twofold. One, it is to review and approve, if appropriate, national security determinations, which is where chief police officers have the biometric material of individuals who, although they've never been convicted, they are regarded as representing such a threat to national security that their biometrics ought to be retained. The second function is to receive applications from chief officers who hold the biometric material of people who've been arrested for qualifying offences and charged but not proceeded with for one reason or another. And under certain circumstances, you can apply to retain those biometrics for 3 years. And that comes to me. And then I have a general statutory role of reviewing how all this material, particularly that is acquired and retained in terrorist investigations, is being used. The surveillance camera commissioner role is very different, even though it's in the same Act of Parliament, the Protection of Freedoms Act. And that involves overseeing the operation of the surveillance camera code of practice, which is applicable to relevant authorities. At the moment, there are only 2 sets of relevant authorities. One is police forces and bodies, and the other is local authorities. And also to encourage the adoption of and compliance with that statutory code.
So let's just talk about the biometrics role at the moment. I mean, everyone will be aware that DNA plays an absolutely vital role in criminal investigations. I think that the database in this country is one of the biggest in the world, and if it's the big, I think 6.7 million profiles, something like that. 660,000 profiles from crime scenes, and the fingerprint database, I think, has got 26 million prints, although that relates to a far smaller number of individuals. How is that all working? I mean, I think people will be interested to know, is it working efficiently? Are the police taking and administering samples and profiles predominantly in the right way? Because the regime has got a lot more complicated since the Protection of Freedoms Act was introduced than it used to be.
It's certainly got more complicated. It has other areas of interaction, such as international exchange of biometrics, which make it even more convoluted. I think by and large, it is operating properly. It's being used professionally, proportionately, lawfully. There are a couple of things I think that are worthy of note at the moment, very practical things. One is that you would probably have seen from the annual reports, not just from me, but from my predecessors, that the single biggest point of failure in capturing DNA from people in custody is failing to seal the bag properly, which is about as low tech an error as you can get, and very easily cured. I'm still trying to understand why and how that keeps happening, but I'm working with police forces and the Home Office to understand that. The other thing,
how many times does that happen roughly?
I don't have the figures in front of me, but I think it is not infrequent. And of those failures where samples are rejected once they get to the lab, a very high proportion, something above sort of 7 out of 10, will be those integrity issues of the packaging, rather than anything around the science, which I think is very frustrating for investigators and the scientists.
So if you don't seal the bag when you take the sample, does that completely invalidate?
Yes, it's been open to the air, and therefore it's open to challenge, and the integrity of the evidential chain is compromised.
And presumably your predecessors and you have warned police forces about this and told them that that's a fairly basic thing that's so important to do.
Yes, and they're all acutely aware of it. Their forensic science managers are very aware of it and roll their eyes when I come and ask, is it still happening? So it is still happening, and I really hope that in the coming year that there's sort of more training, more reflection, more assistance and support in place to bring those numbers down. But in what is scientifically a spectacularly transformative addition to crime investigation and prosecution, it seems slightly depressing that the easiest bit of it is one that's continually going wrong, particularly when you look at how many tests people have done for themselves with a PCR and lateral flow tests over the last couple of years, which I'm told by all the biometrics managers is actually harder to get right than some of the evidential sampling. So we hope that that is on the way down. The other thing is the legislation as currently used in England and Wales by the police means that your opportunity and powers to capture DNA and fingerprints are tied to arrest. And with the very significant increase in the use of voluntary attendance for people to come and be interviewed in relation to investigations, there has been a correlative dropping off very significantly of the number of new enrollments. So the number of new samples and fingerprints that go on the database. And it means that not only does the database or the databases themselves reduce in size, but it means that there will be a significant number of people who have passed through the hands of the police in the last couple of years who have never had their biometrics taken.
Now, just to be clear, this is because when police are investigating an offence, if they, and they've got a suspect that they want to interview, if they're able to do a voluntary interview in order, basically ask the suspect, we want to ask you some questions, they have to do that rather than arrest the person. If they arrest the person, then automatically they can take their DNA. But a voluntary interview, it's a different process. That's essentially it. Am I right?
It's essentially the power to take the biometrics is generally attached to arrest, which itself is slightly problematic because arrest is one of the most constitutionally and legally intrusive things you can do to a citizen, short of incarcerating them in jail. And therefore, you would think that any less intrusive methodology would be preferred. But at the moment, the Police and Criminal Evidence Act provisions mean that if somebody comes in as a voluntary attendant, then they can voluntarily give you their biometrics, but there are limits on that too. And the reduction in people coming through a custody environment, particularly during the COVID-19 pandemic, has meant a correlative reduction in the number of new prints and DNA profiles. And that isn't particularly or exclusively a COVID-19 issue, because my predecessor, Paul Wiles, had pointed it out in his last couple of years of being the biometrics commissioner.
But what it means is that potentially there are people who are not being matched to crime scene samples, for instance, because their DNA isn't being taken, or they're leaving the custody suite, they're going off, perhaps committing another offence when they might have been matched to something and held in custody. All of those issues could be happening.
Yes, yeah, and then at the other end of that spectrum, you have the Metropolitan Police Service at the moment, who are now testing real-time DNA profiling technology, which means that, so when I went to visit them at their forensic science labs in Lambeth last year, they took a cheek swab from me and put it into the new device. And 2 hours later, before I left the building, they handed me my DNA profile, which is pretty impressive.
2 hours. How long does it usually take?
I think sometimes, depending on your forensic science provider, that might be anything up to a week's work, or possibly longer, depending on a queue. So again, provided the entire chain can move at the same speed and you don't create a bottleneck, that is a very interesting and exciting development. But I think what it's also doing is perhaps indicating a general move towards sending the science to the scene, if you like, rather than the way that forensics are done at the moment, which is to send the scene and the suspect's prints and biometrics to the to the lab. So I think that's and again, in terms of being intrusive, that's to be encouraged, I think. So anything that can speed up the process, make it less intrusive for the individuals involved, and make it cheaper, the better.
So the Met is trialing that. Will it also speculatively search the database in those couple of hours as well?
They will do search. They've got some early results that I think they'll be publishing soon, where there have been some very impressive results coming back while the person is still in custody for the original arrest. So it's very significant, and it's a move in the right direction, and it's probably one of those things that happens relatively quietly behind the scenes and perhaps doesn't attract as much attention and discussion as the surveillance camera areas of work.
Well, we'll come on to that in a minute, but at the moment, if a suspect is arrested for a serious crime, how quickly can their DNA be checked against the database at the moment?
I think one of the challenges is to be able to get it through in time for the custody clock, which is obviously ticking from the moment their detention is authorized. So usually you can't. The people are having to be bailed or released under investigation while that process is undertaken.
So there is work underway to speed that process up, which is obviously really, really, really good news.
Yes.
Just finally on your biometrics role, there's a big Home Office program at the moment. I think it's called, is it called HOB? The Home Office Biometrics, but it's some horrible HOB. And this involves, I think, updating some databases and so on. How is that going?
Yes,
on that.
I am nowhere near close to that particular program. Probably just as well for everybody. I think it's enormously complicated and appears to be moving. They were probably recognised very slowly. So my part, my statutory responsibilities engage very little, I think, with that at the moment, and it's a big ambitious program, but it's a necessary one to join things up.
So we're in a reasonably good space in terms of the biometrics that you oversee, certainly, and obviously not forgetting fingerprints, and I think shoe marks as well. You have a sort of a role looking at those databases too, I think.
Yeah, I mean that's one of the things that I've raised with ministers. It's one of the things that I've raised with officials and with policing generally. I think, look, we currently have a situation whereby the principal piece of legislation in England and Wales that governs policing powers, which is the Police and Criminal Evidence Act, is very detailed about what you must do with the boot print of a suspect, but is silent on what you do with things such as facial images, whether they're live or otherwise, and the emergence of new biometrics. So it's so out of date. Very few forces that I go to are even contributing to a footwear index or database anymore. It just simply becomes another piece of information that may or may not assist with an investigation or an inquiry. But to have it regulated so closely by PACE and yet have other areas that the police and the public are very concerned about completely ignored is just not. It's no longer a sort of quaint legal anachronism. It's becoming embarrassing.
Well, in terms of legal regulation, I know that there's been a lot of concern about the facial recognition, which we'll now sort of come on to. And this has been the subject of court challenges and so on. It's been used, I think, by a small number of forces. This is the live facial recognition by the police, whereby a camera takes images in real time of people going about their business or whatever, or a particular event, and then will match them or not with a database of interested people or of suspects.
Yes.
Where are we at the moment? Is this technology being deployed, in anger by police forces? Is there new guidance in place?
I think it isn't being deployed in anger. I don't think it's particularly being deployed in haste. There were definitely some early starters on this, not just here, but also in other jurisdictions, particularly the United States, where there is an impact on the sort of public perception of that, irrespective of the results, or even if it's in your country. There are a number of sort of really interesting points with facial recognition in and of itself. I mean, look, the technology has developed in response to consumer demand, has been driven by convenience. So people want these devices in their own homes and their own private lives as a matter of convenience. But the fact that someone's prepared to use their face and look at a device to open a bank account doesn't necessarily mean that they're happy with the local police using it to track where they went during lockdown for a picnic. So there's some interesting issues around public interest and convenience that are emerging here, which we possibly haven't seen before. There are also different types of uses. So there is difference between scanning a very large number of photographs of unidentified individuals who are suspected of having been involved in offences and running those through an algorithm compared to filming a street and all the activity and people walking past in a live setting, and then comparing that instantly to a watch list. There are some very significant and well-recorded sensitivities publicly, again, both here and in other jurisdictions, about the latter, and the level of intrusion and the proportionality of doing it. If it finds one burglar for every 250,000 people it scans, there are those who would take the view that that's disproportionate and doesn't meet the requirements of the legislation, let alone expectations of communities. But there are equally compelling arguments to say, well, live facial recognition, if it doesn't generally retain a record of your image. If you walked past and it looked, and the algorithm decides it isn't you that's on the list it's been shown, then it forgets you. There is no permanent record. So in some ways, it's arguable that is less intrusive than if the police were out taking footage and still photographs and then sifting through them back at the office. And so there's some sort of nuanced arguments in this that probably need to be thought through. And then the technology itself, which seems to get demonized in a lot of coverage, to say, well, live facial recognition is too invasive and intrusive generally, therefore ought to be very heavily regulated. I've spoken to and met with designers who use this for enriching your experience when you visit an art gallery. So instead of just giving you a commentary as you walk around the different exhibits and so forth, it knows that it's you looking at these things, and it will give you a sort of tailored, bespoke commentary and make sure you're actually looking at the right thing to go with the commentary. Similarly, there are uses in homes for residential dementia patients, for example, where their biggest risk is that they leave the grounds and their relatives and loved ones give consent to say, okay, in the event that happens, we authorize you to use these sort of barrier LFR cameras to trigger an alert to us and say, yes, they appear to have left the grounds. They'll be much more reliable, much more attentive, and cheaper than a human alternative. Part of the challenge in this area and in its proper use is that is exactly the same technology as Chinese companies are using to keep Uyghur Muslims in re-education camps in northern Xinjiang province. So it's really the use case and its proportionality and the accountability of those taking decisions around it that I think are absolutely key. But there are, in all of this technology, whether it's the biometric technology that we just spoke of, or whether it's this kind of new blurring of what used to be CCTV and surveillance cameras, I think that I look at it from three perspectives. There is the technologically possible, i.e. what can be done. There is the legally permissible, what mustn't or what must be done. And then there is the societally acceptable, which is what people will support or even tolerate being done in their name and in their neighborhood. And the first two of those get most of the attention, but there's no question for me that the future of this is being shaped in the third.
You have, I think, said that there's nothing intrinsically wrong with facial recognition technology, and it has a legitimate role to play. I think you have said that in policing. Yes. That's your view.
Yes.
So do we have, and you talked about how society is shaping our sort of acceptance of this and use of it, but we need guidelines. And I know your predecessor was saying all the time that there just isn't clarity. Are there now sufficient guidelines in place? Because the code of practice around the surveillance cameras, I think, has been updated recently. Has that included guidance around the use of artificial intelligence and facial recognition?
It has to a degree. It is very small amendment to reflect some of the key issues from the Court of Appeal judgment in Bridges.
Is that enough? Is that enough for police forces now to be able to use it and stay, certainly within the law and within the guidance?
No, I don't think it is. I'm on record publicly in my contribution to that development of the code as having said that I don't think the amendments go far enough, both in terms of the giving the practical guidance that police decision makers need, and also the not just the legal, but also the ethical underpinnings that the citizen would need to address the issues of how comfortable am I with this and the way in which it's being used. And there is something with facial recognition that I think maybe it's more anthropological than legal, but there is something that people feel less comfortable with than any other form so far of biometric. And given that seems to occur the world over, we need to recognize and take account of that, because more and more in the future, any effective form of biometric surveillance will rely on the citizen, not just the citizen's support, but the citizen's contribution. So one of the first public communications you'll see from a police force nowadays is less about asking for witnesses and more about asking for data that anyone may have captured on a Ring doorbell or a GoPro or a dash cam or whatever. And increasingly, the police and public services are becoming reliant on citizen-generated data. And what they need is the product of an aggregated surveillance capability. Now, unless you have brought people along with you on that, and unless they are convinced that you are using your surveillance capability in an ethical and proportionate and accountable, explainable way, then they may be more reluctant to share that data or to play that part. So there is a shift that I can see now in the surveillance relationship with the citizen, and we need to be very careful of that. So if all we do is focus on the tech and the law, we're going to miss that bit.
So does that call for some kind of public debate or discussion about what we're prepared to accept and understand, that when we send our data from our doorbell or from our dashboard camera to the police, that they're going to use it and how long they're going to store it for and all that kind of thing?
Yes.
We need a debate around that, you think, in order to reach a position that everyone's comfortable with so we can move on?
Yes, we do. So we need to understand where the areas of of concern and sensitivity are. And they will not all be entirely rational, and they may not all be entirely understood by all parties, but some of these are felt responses. I mean, one of the busiest periods I had in this role last year was doing press interviews about proposals by a number of schools to introduce live facial recognition for pupils to pay for their school meals. And I even did overseas news interviews about this. I don't have specific responsibility for schools, although I cover local authorities, but the level of response and concern that generated, which ended up in a debate in the House of Lords, ought to indicate that this is not simply scaling up what we've always done. This isn't the equivalent of taking people's photographs in a public place. But at the same time, if you have very sophisticated, very accurate and reliable technology that will get you onto your plane for your holiday quicker, more cheaply, and more keeping you out of contact, physical contact with others, as you know, in light of what we're all still living through, that itself must self-evidently be a very good thing. But it also makes no sense not to use the available images and information from that same system to keep the plane in the air and make sure it gets where it's going. So when I say that I think there is a legitimate place for this, that's what I mean. Similarly, there are very clear, very loud and well-evidenced human rights considerations that need to be taken into account when you're designing and operating a live facial recognition system. But there is a very powerful human rights argument in respect of Article 3 entitlements, which is your absolute entitlement to be protected from inhumane or degrading treatment, whether that's at the hands of the state or the hands of a serial criminal. And the police have a legal duty to use all means reasonably available to them in preventing that happening. Now, those means are becoming reasonably available at a quicker and quicker rate. More of them have become available since we began this interview. So again, it isn't whether, it's how and under what circumstances and with what safeguards and enforceable regulation and remedies they do so, but they have to do so.
You've made a very powerful argument there that we really need to sort of determine some of these matters because they're so important. Do you think the government are listening to you? Do you think they're ready to do that, or are they just saying, will you update your guidance and that's fine?
Well, let's see. The ministers are listening to me. They are listening as part of a wider consultation that's ongoing at the moment about where these functions and their regulation ought properly to sit. I was appointed to cover these roles jointly for a 2-year period from March last year, which means I'm just coming to the anniversary of my appointment and only have 1 year to go. But the consultation question is still out there. The answers are being reviewed. Again, I'm on public record as having said that the answers may be helpful, but the question probably tells you quite a lot. And the question that was asked in the DCMS survey, which is, should these roles and functions be absorbed by the Information Commissioner, reveals a lack of understanding of these functions by the government in asking that question. It's the wrong question.
What question should the government be asking then?
I think it should be asking what areas of biometric surveillance technology and capability are needed by the police and partners to do the jobs that their communities expect them to do, given the advances in those technologies. So I think this needs an enabling approach, which is the approach that I've adopted since coming in, to say this is not about being a sort of 1970s shop steward where you just hold up the red card every time some intrusive technology becomes available and say you can't use it. It needs to be a careful, measured, informed, practitioner-led discussion about where would our communities expect us to be able to use this to best effect, and then look at how we do that in a legal and proportionate and demonstrably accountable way. So I think, yes, look, there is some merit in saying, how many commissioners does it take to change this light bulb? But that can't be the entirety of the question. I think simply rearranging some of the regulatory furniture is unimaginative, and it's not nearly practical enough to make a difference to the people who are policing. So I've been to a number of forensic science and biometrics teams last year, and none of them seem to believe that moving these functions would actually make any difference. It wouldn't be better or worse. It was almost, why would we care? What we need is legislation that allows us to take samples at the point at which we need them. It gives us enough time to turn those around and make the investigative or other policy decisions that are thrown up by those biometrics. It needs us to know where and to what extent we can confidently use new technology and how we need to go about it. And when we move into areas of artificial intelligence, that is going to be absolutely critical, because the deployments will be situational, and therefore the circumstances will change all the time, and the governance and accountability of those then needs to be more gyroscopic. It can't have a straight line, here's what you must do, here's what you mustn't do. We're not in that territory.
Well, let's see if the government is listening. Let's see if your roles do get merged and put into the Information Commissioner's office, or indeed whether they decide that to take the approach that you're suggesting. Fraser Sampson, thank you very much indeed for joining me on Policing TV. It's been really interesting. Thank you.
Thank you very much.